a person has been sentenced. Some were sentenced to 2 years and 8 months. Some were sentenced to 2 years and 6 months. Some received suspended sentences. And one person has still not been sentenced because he refused to plead guilty. But now, the most important question is, where is the written judgment?
A person has already been sentenced, his freedom has already been taken away, his fate has already been changed, his family has already endured nearly a year of waiting, worry, and pain. But if the family and the outside world cannot even see the written judgment, how can we know what facts the court identified? How can we know what the evidence was? How can we know what the legal basis was? How can we know whether this judgment can withstand scrutiny? This is the second issue I want to talk about today. A person has been sentenced, but the written judgment is still unavailable. Is this normal? Let me make one thing clear first. Today, I am not making a legal conclusion because we still have not obtained the complete written judgment, and precisely because we have not obtained the judgment, many key questions cannot yet be verified. But exactly for this reason, the written judgment becomes even more important. On June 15, 2026, according to currently public information, the Linzhou People's Court in Henan Province issued judgments against several members of Lifechanyuan. Henan Chao was sentenced to 2 years and 8 months in prison. Shengong Chao was sentenced to 2 years and 8 months in prison. Shenxian Chao was sentenced to 2 years and 6 months in prison. Xian Chao received a suspended sentence. Shihui Chao received a suspended sentence. Zhishir Chao has not yet been sentenced because he refused to plead guilty. These are not simple words. This is a person's life. This concerns whether someone can still live freely in the coming years. It concerns whether their family can see them, care for them, and appeal on their behalf. It concerns how a community is characterized. It also concerns whether the public can see the judicial process. So what exactly is a written judgment? A written judgment is not a simple notice. It does not end by merely telling you how many years someone was sentenced to. A written judgment should tell us what facts the court found, what evidence the court accepted, what defense arguments the court rejected, which law the court applied, why the court believed the person was guilty, why the court imposed this sentence, what the appeal period is, and which court hears the appeal. Without the written judgment, the so-called judgment leaves the outside world with only a result. But justice cannot consist only of a result. Justice must have a process. It must have facts. It must have evidence. It must have reasons. It must allow people to question, appeal, petition, and seek review. Otherwise, how can an ordinary person know why they were sentenced? How can family members know where to begin an appeal or petition? How can lawyers determine whether there are problems in the judgment? How can society judge whether the case was fair? This is especially true in a case like the 2572 incident. This is not an ordinary single-person case. It began on July 2, 2025, and involved at least more than 80 Lifechanyuan members being arrested, summoned, or interrogated. It involved multiple places, including Shenzhen, Linzhou, Zhengzhou, and Shandong. It involved long-term detention. It involved a charge that greatly needs clear explanation, using superstition to undermine the implementation of law. It involved thought, belief, communal life, online articles, donated funds, personal privacy, and many other complex matters. The more complex the case, the more it needs openness and transparency. Because what the outside world most wants to know is not only how many years were they sentenced to, but what exactly did they do? Whom did they harm? What superstition did they supposedly use? Which law or administrative regulation did they supposedly undermine? What evidence did the court rely on to establish a crime? Was the evidence public articles, chat records, donation records, activity videos, or statements from those involved? If there were statements, under what circumstances were they obtained? Were there situations in which people were pressured to write guarantees, repentance statements, or denunciation statements? Were people pressured into making statements against their true will? Without reading the written judgment, these questions cannot be judged. Some people may say, the court has already ruled, so there must have been a problem. But this is not rule of law thinking. True rule of law does not ask people to blindly believe a result. True rule of law allows that result to be examined, verified, appealed, and supervised. Others may say, you are not the parties involved, why are you concerned about the written judgment? Because a criminal judgment from a public trial, especially a case involving multiple people, faith, and communal life, should not exist only as oral retellings among a small number of people. The written judgment is the bridge connecting facts, law, and public trust. Without the written judgment, the parties have difficulty appealing effectively, families have difficulty petitioning according to law, lawyers have difficulty determining the direction of defense, the media have difficulty verifying the facts of the case, human rights organizations have difficulty conducting independent assessment, and the outside world can only speculate based on incomplete information. Speculation is not good for any side. If the court's judgment is sufficient, then the written judgment should be able to explain it clearly. If the evidence is solid, then the written judgment should be able to list it. If the application of law is accurate, then the written judgment should withstand reading and discussion by legal professionals. So now, when we ask to see the written judgment, it is not to create confrontation, it is not to attack judicial authorities, it is not to stir up emotion. It is to return to the most basic questions. Please lay out the facts, please lay out the evidence, please lay out the legal basis, please allow the parties and families to exercise their rights according to law, please allow this case to withstand scrutiny under sunlight. This is not an excessive request. It is a basic procedural right that a sentenced person should have. It is a basic right to information that families should have. It is also the minimum precondition for society to judge whether justice has been done. In the 2572 incident, we are especially concerned about how the written judgment will explain this charge. The crime of using superstition to undermine the implementation of law. This phrase sounds very serious, but the more serious it is, the more clearly it must be explained. What is superstition? Which ideas of Lifechanyuan were identified as superstition? Was it expressions about life, the soul, karma, or the afterlife? Was it certain rituals? Was it certain articles? Was it certain ways of living? And what law's implementation was undermined? Which law? Which administrative regulation? What specific acts? What consequences were caused? Were there clear victims? Was there specific harm? These questions are not sophistry, these are questions that must be answered for a conviction. Because if a person can be sentenced merely for believing in a spiritual idea, participating in a communal life, or reading or spreading some public articles, then that boundary must be extremely clear. Otherwise, every person with different ideas, different beliefs, or a different way of life will feel uneasy. I also want to say this to those who are not familiar with Lifechanyuan. You do not need to immediately agree with Lifechanyuan, you do not need to immediately believe every word we say, you can even remain skeptical. But at the very least, you can support one basic principle. Anyone who is sentenced should know why they were sentenced. Any family should obtain the necessary legal documents according to law. Any major case should withstand public examination of facts and law. Today, when we ask about the written judgment, it is not because we are afraid of the truth, on the contrary, it is because we hope the truth will be presented in full. If members of Lifechanyuan truly committed crimes, please disclose the facts, evidence, and legal basis to a degree that can be verified. If they did not commit crimes, if they merely upheld a belief, chose a different way of life, and participated in a spiritual community, then they should not be detained for a long time, and they certainly should not be sentenced. The written judgment is the first key to opening all these questions. Without it, we can see only the result, not the reasoning, we can see only the sentence, not the evidence, we can see only the conclusion of power, not the argument of law. A truly just judgment should not fear being read, it should not fear being discussed, it should not fear scrutiny by lawyers, scholars, media, human rights organizations, and ordinary members of the public. So in today's video, I want to raise only one very simple question. The person has already been sentenced, where is the written judgment? If the judgment is just, please let it be seen. If the procedure was lawful, please let it withstand verification. If the facts are clear, please write them out. If the evidence is sufficient, please list it. If the application of law is correct, please let people around the world who understand law read it. Because the dignity of justice does not come from keeping people from seeing it, the dignity of justice comes from being able to withstand being seen. The 2572 incident is still ongoing. A judgment is not the end. The written judgment is not a small matter. It affects whether detained people can appeal, whether families can petition, whether the outside world can verify the truth, and how this incident will ultimately be recorded.
I will also continue organize testimonies and evidence index of this case, because after a person has been sentenced, we should at least know why they were sentenced.